My name is Steve Reed. I'm one of the 3 Columbia County Circuit Court judges. I'm here to welcome you to mediation and to encourage your participation and involvement in mediation. We recognize that legal proceedings in general are difficult. Custody and parenting time issues can be extremely difficult, and we encourage your open and honest participation in mediation to make a parenting plan that works for each of you and your children. Mediation is an opportunity to sit down with trained professionals to help you develop a parenting plan, custody and parenting plan that works for your specific family. We urge you to be open, honest, and participate in that mediation. You need to understand that the needs of the children need to be placed first and not your particular needs. Experience tells us that going to court at trial and having a judge develop a custody and parenting plan frequently leaves both sides unhappy. Your open, honest participation, giving a little, taking a little, will develop a parenting plan that, while neither of you may be completely satisfied with, will be the best plan for the 2 of you and your specific family. Please know that as a judge, I do my very best to develop a picture of your family and your children at the time of trial. I place the interests of the children first, as the law requires me to do. The best, however, that any judge can do in a 1-day or 1-day plus trial regarding custody and parenting plan is to get a brief snapshot of your life. Who knows the 2 of you better than the 2 of you? Trial is difficult, expensive, and frequently very unsatisfying. Mediation, on the other hand, is confidential. Nothing you say in mediation can be used in trial. It is an open exchange, a give and take of ideas and issues that, if you come to the table openly and honestly with your children's best interest in mind, can work. It can work very well. If you have concerns about abuse, please talk to your attorney, your facilitator, your mediation facilitator, or the state court administrator about those issues. We can resolve them for you in a manner that makes it safe for everyone to participate in mediation. In the next portion of this video, you will hear from mediators about their role in this process. I urge you to pay close attention to that, as they are experienced and have a tremendous success record. Again, on behalf of all the judges from Columbia County Circuit Court, I want to encourage your open and honest participation in mediation to develop a custody and parenting plan for your children. Again, it's not for you, it's for your children. We also require that you attend a parent education class as part of this custody and parenting time, and we require you to get that done as soon as possible, hopefully before mediation.
Hello, I'm Diana Taylor. I'm one of the mediators on the mediation panel for the Columbia County Circuit Court. I've been a mediator since 1997 and have mediated a variety of cases, including business law, employment law, and family law cases with a specialty in custody and parenting time cases. I'm a local girl. I live and work in Columbia County. I have an office here in Old Town St. Helens, located at 203 South First Street, which is across the street from the Vault and the Columbia Theater and next door to Wild Current Catering. It's 1,200 square feet with a large conference room, 3 smaller offices, so if things get a little tense during mediation, I'm able to separate the parties, speak privately with them, and at the end of the day, I prefer to have the parties back together in the same room, because I won't be around for the next 18 years running around from one office to the other to resolve parenting issues. We can separate the parents when it's necessary, if things get a little tense or if someone wants to speak with me privately. But my goal is to have parents get together and reach a level of communication that works for them and their children so that as they go forward in life, they don't have to rely on third parties to help them work out their parenting issues. If you have a safety concern, please let the mediator know at the time of the initial intake. What I do is either I or my assistant will call you to set up the appointment, go over some of the issues, find out what your concerns are in working with the other party. If you have a restraining or no contact order, in a perfect world, we would like you to fill out a motion asking that that order be modified to allow contact for purposes of mediation only. That way you can still be safe in having the no contact or restraining order in place outside of the mediation context. But during mediation, you'll be able to be in the same room or at least the same building. If you're not comfortable with being in the same room, like I said, I can split you up over the different rooms and do what's called shuttle diplomacy, shuttling back and forth between the two of you. If the safety concerns are more serious and it just is not safe to meet in the same building, what I do is I have one party appear in the office and the other party appears by phone. This also works very well and makes sure that everybody stays safe. I have a very flexible schedule. I'm available evenings and weekends to accommodate those with busy school or work schedules. And like I say, I'm just here in Old Town, St. Helens, so my office is easy to find. Occasionally we have cases where one of the parents lives a distance away, perhaps out of state or in Eastern Oregon. Those parents can also appear by telephone. And the other parent is in the office while the other parent appears by phone, and that also works well. Sometimes I have people come to mediation, and you can tell from the body language that that is the very last place on earth that they want to be. Their arms are crossed across their chests, and their chin is down, and they're going, "This is stupid, I don't want to be here, why is the judge making me do this, it's not going to work." I think you'll be pleasantly surprised. For a lot of couples, they haven't had a conversation since all of this started. And they've read the paperwork that has been filed with the court, which may contain allegations that the parent never even came up with. It could be something that the attorney put in the paperwork, or something that a friend recommended be included in the paperwork. Mediation gives the parents an opportunity to sit down in a safe and neutral location and actually talk about their kids. And you can disagree on everything else. You can have arguments about who should have taken out the trash, who should have folded the laundry, who didn't get the oil changed in the car. But when you get right down to it, you love your kids. And you're doing this for your kids. And when you sit down and realize that that's the one thing that you do have in common, then everything else starts to fade away because you're focusing on your children and what they need. And as a result, most mediations are largely successful. Occasionally, I'll have a parent say, "Well, why should I go to mediation? Actually, we get along pretty well. We're not like those other parents. And we have something pretty well worked out. We have a parenting schedule that we've been following that works pretty well." That's excellent. That means your mediation won't take as long. But I'm a wordsmith. I've been doing this since 1997. I also know all of the judges in Columbia County. I'm in their courts almost daily. I can put together the paperwork for you that has the language that needs to be included. I may think of issues that perhaps you haven't thought of. And I can take your ideas, your plan, and incorporate them in a document that is acceptable to the court and will be long-lasting for you. Other people say they want a more flexible agreement. They don't need everything spelled out. That's fine. The parenting plan becomes a guideline for what happens down the road if you're unable to agree. If a dispute should arise, you can always go back to the agreement and say, "Oh, see, I'm supposed to have the child for Christmas this year. You get the child next year for Christmas." There are no parenting time police out there saying, "You were supposed to have done this, that, or the other." You can make whatever modifications you wish to the agreement as long as both parents agree. For other parents, they need agreements that are a little bit tighter. The agreement level isn't as high as some of the other parents, and they need a little bit more structure. I can certainly do that as well. For parents who are not represented by counsel and need an actual order for the judge to sign, instead of just preparing a mediated agreement, I take the standard order that's available through the trial clerk administrator's office, and I prepare that order for you. So at the end of the mediation, both parents can sign it. It's called a stipulated order, meaning both parents agree. And once the parents sign it, it gets shipped upstairs to the judge signs it, and you're all done. You won't even have to come back to court. So the other advantage to mediation, besides saving time, money, and frustration, is that studies have shown that if parties go to court and actually wage a war and rely on a third person, such as a judge, to make the decisions for them, those decisions rarely work, and there's a very low level of compliance. People don't necessarily care that the judge has signed an order ordering people to do this, that, or the other. Whereas if each parent helps craft the agreement and create the language and the terms and what it is that the parents are agreeing to, the parents are both much more likely to comply with the terms of that agreement, much more likely to have actual conversations in the future if problems do arise, and much more likely to solve the problems without getting third parties involved like attorneys and judges. So it'll save you repeat trips to the court in the years to come. Give mediation a try.
My name is Peter Johnson. The Columbia County Court has asked me to speak about my background and approach to mediation. I got involved in mediation while I was finishing law school in 2005 doing community mediation. And I found that resolving disputes between neighbors, like barking dogs or property line disputes, was a great way to resolve those kinds of issues because it was with people who were going to have an ongoing relationship as neighbors. And later I got involved in family mediation or domestic relations mediation. And I found that this was also a great way to help parents who were ending their relationship as intimate partners, but who were going to have an ongoing relationship as co-parents to resolve their differences and to reach agreement. I did an internship with Clackamas County Resolution Services and had the opportunity to observe other mediators and to be observed and to really understand what mediation is and how it can help families. I started as a mediator with Columbia County in 2009 and have worked with hundreds of families in resolving their differences and reaching an agreement and creating a parenting plan. Generally, my approach to mediation is to meet with each parent individually. I want to hear a little bit about what's been going on and what you would like to see happen going forward. I often, when I meet with parents together, I often ask parents to show me pictures of their children so that I can visualize who these people are, and really that's why we're there, is to figure out how both parents can be involved in the children's lives and to figure out a plan that will help support the growth and development of your kids. I've worked with many parents who were convinced they were not going to be able to reach agreement in mediation and were surprised to find that they were able to reach an agreement in mediation. Many parents are able to reach a partial agreement in mediation, and that's great. A judge will honor whatever agreements you have made and will make a decision on whatever is unresolved. So any issues you can take off the table will help save you time and money in court fees and legal fees. Generally, everything that's said in mediation is confidential, so I'm not going to voluntarily share with other people what's said in mediation. That gives parents the flexibility to talk about different possibilities without being bound to those agreements. Nothing is final until you and the other parent sign your agreement and it's submitted to the court and signed by a judge. Your participation in mediation is required by the court. However, you're not required to reach an agreement. So you should not feel pressure to agree to something that you don't feel is best. You can also end a mediation session at any time. Some parents have safety concerns, and I hope if you do have safety concerns, you let me know what those are so that we can make arrangements to address those concerns. Some parents choose to meet separately for safety reasons, and if you would prefer to do that, please let me know. One of the great things about mediation is that you as parents are able to decide what arrangements you'll make for your kids. And when it goes to court, it's out of your hands to a great degree. A judge has to make a decision. Most judges don't want to make these kinds of decisions for your family. They'd much prefer that you as parents reach a mutually agreeable arrangement. Now, to avoid problems in the future, I encourage parents to be as specific as possible. Pick up and drop off times, the regular parenting time schedule, holiday schedules. I encourage parents to be as specific as possible because when you're getting along, you and the other parent can do whatever you'd like in terms of different arrangements that vary from what's in writing. But when you disagree, it's important to have something specific to fall back to. And for that reason, I encourage parents to envision a situation when you're not getting along so that you can plan something that will work for you, for the other parent, and most importantly, for your children. Now, typically I meet parents in Scappoose, but I try to be as flexible as possible in meeting with parents at a place that's convenient for them, whether it's in St. Helens, in Portland, or Clatskanie. My schedule is flexible, so I'm able to meet parents during the day, evenings, and some weekends. I do my best to find a time that's convenient for everyone. Now, only parties to the case can be present for mediation unless all parties agree that someone else can be there. Sometimes it's helpful to have a new partner or a family member there. Sometimes it's unhelpful. So it depends on the situation and what both parties are open to. If you and the other parent speak with each other primarily in Spanish, I am fluent in Spanish and I'm able to conduct the mediation in Spanish if that is your preference. That's all I have, and I wish you well, and I look forward to working with you in mediation.
On behalf of the judges from Columbia County, I want to once again encourage your participation in mediation. This is your opportunity to craft your own solution to this difficult situation. There are now 3 things that you need to do to begin mediation. First, make sure I get this correct, submit your mediator request form to the court. Number 2, to attend the parent education class. And number 3, to arrange your mediation appointment. You can find more information on our website, courts.oregon.gov/Columbia. Thank you for your attention, and I wish you the very best in mediation.